Hi, and welcome to today's Privacy Law Forum Life Sciences session. This session is sponsored by the Berkeley Center for Law and Technology's Life Sciences Law and Policy Center. My name's Allison Schmidt. I'm your host for today, and I'm the director of the Life Sciences Center. So it's my pleasure to welcome two privacy experts from Morrison Foerster to talk with us today about international data transfer regimes. We're going to be exploring the question of whether we're all becoming data islands. So we're going to be talking today with Lokke Moerel and with Kaylee Cox-Bankston. So Lokke is senior of counsel in Morrison and Foerster's Amsterdam office. I will say that she is one of the world's best-known privacy and cybersecurity advisors. I encourage you to check out her work. She has an extensive publication record. She's a real deep thinker in this space, and we're very lucky to have her with us. Along with Lokke, we have Kaylee Cox-Bankston, who's a partner in the Privacy and Data Security Group in the Washington, D.C. office for Morrison and Foerster. Her practice is very expansive. She advises clients across all industries on complex cybersecurity, privacy, and data matters. So with that, I'm going to turn the program over to Lokke and Kaylee.
Thank you, Alison. Nice to be here again. Yes, international data transfers. For the US, for a long time, the mantra was that data could flow anywhere. And if there were any restrictions, it was very much in the European Union and the UK. And by now, other countries like Argentina and others. But the US has a big change as well, and Kaylee will be speaking to that later on. We want to pose to just show you two questions to show how extensive those regimes are and how quickly they come into play. So the first question is European laws, transfer rules. Just imagine you're a research institute and there's a rare disease. Children die young and there is no cure. You want to study degradation of human movement, kinetics. In the Netherlands and Belgium, they have a large database which you can access on a remote basis to perform your research. So you're not transferring the data to the US, but it remains in Europe. The results, when you get them in the US, are anonymized before you download them to the US. Are the EU data transfer rules triggered? And the answer is yes. Even if you have access, it will be the transfer rules will apply. Kaylee, one example for you.
Yeah, so let's do an example from the US perspective. So let's assume we have a US hospital that contracts with their research team in Shanghai to conduct non-clinical research and analytics on rare diseases. They're conducting the research at the patient level, on patient level data, which has been de-identified in accordance with HIPAA's de-identification standards. So it is meeting the standard for de-identification under HIPAA. And over the course of a year, the team analyzes the de-identified data on approximately 25,000 US patients. So the question is, would this new US DOJ bulk data rule be triggered? And the answer would be yes. We'll talk more about this later in the program, but doing things like de-identifying or anonymizing data does not take you outside the scope of the rule, which is a pretty big shift in the US. So we'll come back to that and talk through how that applies.
Good. Thank you, Kaylee. So, well, the EU rules are data ready from 1995 and really are the rationale is that it is protection of human rights of individuals. And the data is normally in the EU, but when the regime of protection that is there in Europe is tagging along once you transfer the data. So it is really rights-based. And in the US, the rationale is completely different. It's national security, and we'll hear later from Kaylee how that works. The interesting part is that by now, the transfer rules in Europe started out as protection for fundamental human rights. And I'll explain the rules in a sec. But Europe is now deploying these rules also to protect its digital sovereignty. So how do the EU transfer rules work? There is a prohibition to transfer the data, personal data outside of Europe. That is the starting point. And then there's a number of exceptions. One of them is if the European Commission actually checks out the law of a country or a region or a certain group of companies, and then considers, you know, the law, the practice, assesses it and considers it adequate and issues an adequacy decision. That is what happened with the EU-US data privacy framework, is that the companies in the US that adhere, certify under that framework are considered adequate, and Europeans can transfer European data, personal data, to the US if those companies adhere to that data privacy framework. If a country doesn't have an adequacy decision, then there's some other exceptions, namely the main one, that the data exporter and the data importer can agree and enter into standard contractual clauses. That's a standard contract trying to protect contractually the data transferred to, for instance, I don't know, any other country outside of the EEA. The point is, the EU-US data privacy framework, the predecessors have been nullified by the European Court a number of times for reasons that there were extensive surveillance powers in the US. Then again, the European Commission agreed on a new framework, which is now still into place, but already it is being challenged before the US court. So we will have to see how that pans out. So the data transfer rules apply also if there's access to EU data. The data doesn't actually have to be transferred, for instance, to the US. It also applies, like Kaylee just said, when the data is de-identified. It's only that they no longer apply if data would be fully anonymized. And I tell you, that is a test that is very, very difficult to make. And also, if, for instance, data is encrypted, it's considered a security measure to encrypt data, but not sufficient to get out of applicability of the GDPR or the data transfer rules. So what we've seen lately is that the European data protection authorities take a very strict approach to data transfer and the rules. The transfer rules should be risk-based, but basically they take an absolute approach. And the main reason is that it's basically for geopolitical reasons. It is no longer just about data protection. It is about EU digital sovereignty, about the data of EU companies and citizens being here in Europe, so we're not dependent on something going wrong in the US, or to be able to use that data for innovation here in the EU. Well, if that data is all locked up in proprietary cloud systems, it's just more difficult to innovate with that data and combine it in that many companies combine the data, for instance, for training of AI. So basically, these rules are deployed to force big tech to set up shop here, to provide jobs here, to train their employees, and also that these then can move to other companies here in Europe that maybe not the big tech companies. So for a moment, it's looked very dire because the European Court annulled the predecessor of the privacy framework. By now we have the new framework and everybody thought, okay, business as usual. But that is not really the case. Max Schrems, the activist, privacy activist from Austria, who filed the court cases against the predecessors and won, also filed a new complaint. And he said, I'm going to file complaints until all big tech have changed their business model and also provide services here in the EU. And he can make the case, especially with all the changes as to the requirements of the privacy framework. There's certain safeguards that are maybe no longer there. So it is a risk. A year ago, I did a session at the IPP conference in Brussels together with Paul Nemitz. He's the policy advisor on anything digital to the European Commission. And he was also very clear about this. Look, we expect companies in Europe to have their books and records here in Europe. Also their annual accounts to be at the company premises. And that is the same for their data. We want their data where it belongs. And the interesting part is that the large cloud providers by now realize this, and they are all implementing what they call digital sovereignty measures. And I'll show you some examples later on. So the question is, should Europe be worried? And the basic answer is yes. There's so many more transfers than before, and that is due to the implementation and move to the cloud by a lot of companies. And the result is that our dependency of US hyperscalers is becoming is increasing, and we don't really have an alternative anymore in Europe. And those dependencies will increase with implementation of AI. Another thing is that the cybersecurity threats are increasing. It's not the topic of today, but China is, the threat from China is really getting out of hand, and they are using data as a weapon. I'll explain in a minute. So this is one of the speeches of Ursula von der Leyen, and she said, look, we need to have tech sovereignty. What it means is that we shouldn't become too dependent on China and the United States and must be more able to meet our European needs. So what are the threats? One of them is what they have coined data colonialism or tech colonialism or digital colonialism. Basically, the Draghi report, which was on the big report of 800 pages on the competitiveness of Europe, which was dreadful. We are far behind the US and China. And one of the main issues he flagged is that the data value loss is about 90%. 90% of our data, of our Europeans, citizens, companies, governments, is going outside Europe, and that is considered a long-term risk of loss of industrial know-how. This is the overview of the cloud market in Europe. And you see 2025, we're not completely there, but the prediction is that it will grow compared to 2024. You see how quickly it grows. And the real issue there is not that the cloud market is growing, but that the market share of the US hyperscalers is growing, and that actually the market share of the European providers, you can see that at the top, Deutsche Telekom, OVH Cloud, Orange, is actually relatively shrinking. So one of the things and recommendations of Draghi in his report is that say, look, Europe needs to go for data localization. It will be important to be able to innovate so industrial sectors like health or automated cars can combine their data in European data spaces, which is another EU regulation, and then used for innovation. And why is everybody so concerned? One of them is the executive order already from President Biden, but continued by President Trump. And basically that the US cloud hyperscalers need to notify the government, US government, about acquisition of cloud capacity used to train advanced AI models. So they need to flag their customers, and then that enables the US government to act against anything they find unwarranted, models that are trained there that they think are against violating US rules, but also to prioritize the need of the US for compute capacity for national AI project. We had a similar displacement issue, as we call it, with GPS satellites, and that ultimately triggered Europe to set up its own system for GPS Galileo. So what we see now is a kind of perfect storm of conflicting interests. There's the concerns on the one hand of EU digital sovereigns, data of European companies being in silos in the cloud of the US hyperscalers and not available for European innovation. We are dreadfully behind in the AI race. And the GDPR has a lot of unintended consequences. It is actually a competitive advantage for big tech because they have the money to innovate and actually comply with the GDPR requirements. Some examples for another time. But also GDPR is sometimes used as a shield not to for the big tech not to share data for innovation here in Europe, because they say, well, it's personal data, and they're rightly so, but it is a limitation of European innovation. So then the million-dollar question is for Europe, for the Commission, is how do we open up European data assets across the different sectors, where we provide more control to the individuals if it's personal data, and control to companies, organizations if it's their data, while at the same time protecting EU values without making big tech even bigger. So they came up with a number of policy starting points, principles, and they said, look, it's not a good idea to have our own big hyperscaler if that would be possible. Main reason, if we have complaints about big tech, we would have similar complaints about European big tech. So what they want is open infrastructure. It's about interoperability, to be able to scale up, not in a vertical way like with the hyperscalers, but connecting all the offerings and scale up in a horizontal manner. They want open data, that is then the regulation on EU data spaces, where you can combine data on health and then have a regime around it for access and innovation. It's actually quite clever, but for another day. They like everything to be open source, because then you can innovate with more parties on the same technology, hopefully matching the budgets of big tech. Difficult to do. And they want federated solutions, so data remains where it started and is drawn when required. So basically what they want to do is flip the ecosystem. They want to give more control to the individuals, the companies, rather than the hyperscalers, where data of companies is stalled but is actually used by them for innovation rather than the companies themselves. So this is a list of legislation where they start opening up data. It's about financial data. It started with payment data, but now we will also cover insurance data. It will IoT data, internet connected digital products. Then companies will be able to get that data rather than that it stays with the provider of the digital project. The Data Governance Act tries to open up all the public data, and then even if it's protected, but that it can be used for innovation. The Digital Market Act requires the big companies to open up their business data to the companies themselves. I can go on and on, but it is about access by the companies whose data it is, interoperability between platforms, and also data localization. There's very strict transfer requirements for all these laws. And why? Because they don't want foreign companies to benefit of all those open data initiatives. So the response of big tech is actually quite a good one. They've seen this coming, and since 2022, we saw that AWS, Google, and Microsoft launched what they called a European sovereign cloud. And what it was is that Europeans could choose where their data was residing, so on what servers in the EU, but also that there were the metadata relating to the use of the services would remain in the EU rather than going to the US. And next was that anybody servicing those clouds in Europe would also be resident here in Europe, rather than that service or emergency support would be done from the US. So they're training people here, etc. And they all did that. So I noticed here Amazon, but the others did it exactly like that. But very recently, I mean, this is the 3rd of June, AWS now said, look, we're going one step further. We are also going to have EU companies and EU supervisory boards, and it will be completely independent. And with a lot of measures also for backup of the code to actually run the cloud if something disastrous would happen, or the US administration would claim capacity for the US. Microsoft did a similar thing in 2020. So they announced the data boundary, similar requirements. And now in April, they said, look, we do 5 more promises. And those are quite far stretching. I listed them. They said, look, we've now completed the EU data boundary project, but we will increase our data center capacity in Europe with 40%, ultimately 216 countries. So we have more resilience. The cloud services will, at request, be operated under the control of an EU company. So the Trump administration wouldn't have jurisdiction anymore. There will be EU entity, EU board, EU deputy CISO. They will contest and fight any US executive order, and there will be a full backup of the escrow. So that is, and Google did exactly the same. So that is a major change. Another thing I want to flag, because it gives the bridge to what Kaylee is talking about for the US data bulk transfer regime, is that data is by now used as a weapon by especially China. This is Robert Reich, you must know him, and he said, and I think it's already a long time ago, cybersecurity comes down to which side has access to more information about the other and can utilize it best. And that is about trying to weaponize your data and information about what you know about, military developments, spying. It is using that information to try to corrupt people and trying to steer them in the right direction. So what they do is China harvests just anything they can find on the internet. So that is one. But what they also do is anything that is encrypted, they also scrape. And they store that in data centers with the aim that with quantum computing, they will be able to decrypt the data and then analyze it and then have even more information about Europe and the US. They also try to innovate as much as possible using all that data in the health space. There's a kind of health race going on, like the space race, it's now the health race. Just imagine they have new medicine and all types of solutions we do not have. You become dependent on them in case of a pandemic or certain, but also it's again a manner to, if your wife or your husband is ill and rare disease and China can save them, you will do a lot to at their request in spying and sabotage if it comes down to it. They take extreme measures. During the COVID pandemic, they actually offered all the governors in the US states, the like free cost testing centers. And the offer was too good to be true, but basically what happened is that all the samples would go to China from which you could derive DNA, etc., and they would have a really good view of the US population. It's when those governors started to talk to each other that they thought this is too good to be true indeed, and politely declined. But the bottom line is, if you can combine DNA data with TikTok data, which is socioeconomic data, that is really, really irrelevant for personalized medicine solutions. So you think data is, what can they do with TikTok data? What can they do with, but that is what is going on. Haley, over to you.
Yeah, no, thanks. That really sets up kind of the frame of mind behind the new bulk transfer regime here in the US. So the regulation is implementing President Biden's executive order. And the DOJ will run the program, and it's focused on access to data. So we're going to spend the majority of today talking about, we call it the bulk data transfer regime. The DOJ calls it the data security program. It has many different names. The official name is very long. But there's also a separate regime called PADFA, which is a narrower in some ways, and it will be administered by the FTC. So we'll talk about that briefly at the end, but the majority of our discussion today will focus on the bulk transfer regulation that implemented President Biden's executive order. And I should just note that the concept that underpins this framework actually started under the first Trump administration, and then Biden carried it forward and through his executive order, and now with Trump's second administration, all signs are pointing that they are going to go forward with and enforce this regulation. So we can go to the next slide. Yeah, so just to give some context that explains a little bit about what was driving this transfer framework, is this New York Times study where they looked at a bunch of anonymous data that was just publicly available through apps. You know, you're sharing location information with different apps, anonymized information that was available that when taken together, were actually able to amass profiles and get very granular details about individuals and able to identify them. So identifying churches that people were going to, political affiliations, identifying their home address, because they were able to look at massive amounts of data. Although it was claimed to have been anonymized, you still can ascertain a significant amount of information from anonymized data. So that's kind of one of the things that was driving the regulation and the premise behind it. And so for that reason, the regulation does apply to anonymized data in addition to de-identified data and encrypted data, as we talked about from the EU perspective. So that's a pretty big shift, because I think a lot of companies think the data is anonymized, then we're falling outside the scope of data privacy restrictions, and that's simply not the case when it comes to the US bulk data rule, and that is by design. So just a high-level overview, and then we'll dig into some of the specifics. We're not going to have time to walk through everything because this law is so dense and complicated, but we'll hit the high points in our discussion today. So like I mentioned, the DOJ National Security Division will be administering and enforcing the program. It carries both civil and criminal penalties. There are things called general licenses and specific licenses where companies can request or be licenses to conduct activities that would be regulated under the regime. And we anticipate there'll be advisory opinions and a voluntary self-disclosure regime, but that has not yet happened. So we're in very early stages. The law technically took effect on April 8th, so it is in full force in effect. But the Department of Justice came out a few days after April 8th and put out some guidance that essentially said, if you are working in good faith to try to comply, because they recognize that it is very impactful for a lot of companies, then they will not prioritize enforcement against those companies that are working in good faith to try to come into compliance, but that they fully expect companies to be in compliance by April 8th. So that was some welcome news for many, but between April 8th and July 8th is not that much time, but it's more time than people had. So I think some companies may have been waiting to see with the new administration and some of the regulatory actions in terms of new laws taking effect, what this meant for the data security program. But all signs point to this going forward, full steam ahead as planned. So there may be additional guidance that comes out either before or after the July 8th timeframe, but this regulation is technically in effect as we speak. So just to kind of give an overview of what the components of the program are, it really focuses on access to what is called bulk U.S. sensitive personal data or U.S. government-related data, and we'll talk about what that is. But it's important to note that this regime is industry agnostic. So unlike some of the federal privacy regimes in the U.S. that are focused on healthcare or financial services, this is intended to apply pretty broadly across the board. There are exemptions that we'll talk about, but they're nuanced and intentionally so. So this is a very broad sweeping regime, really first of its kind in the US. We typically have not had a law that would apply kind of across industries that would prohibit data transfers outside the US or restrict them. So this is pretty groundbreaking from a US perspective. And so what it is it focuses on restricting access to this type of data to what is called a country of concern. So those are countries that the US has determined pose some sort of national security risk to the United States, and therefore access to this type of information also poses a national security risk. They're broken into prohibited or restricted transactions. Prohibited transactions, as you may imagine, can't happen at all. Restricted transactions can go forward, but they come with onerous security and compliance obligations, and there's still a requirement to prevent access by individuals in countries of concern. So it's still pretty onerous, even if it is a restricted transaction. And then there are exemptions, like I mentioned, but they're pretty nuanced and limited. Go to the next slide. Great. Okay, so like I mentioned, there are two different types of data that's covered. There's bulk US sensitive data and US government data. So the bulk US sensitive data only is covered if you're over certain thresholds. So as you can see from the thresholds on the screen, the government is most concerned about human omic data. So if it's genomic data, accessing data for 100 unique individuals would put you over the threshold, and it's over the course of a 12-month period. So if there's access to 100 individual genomic data sets over the course of 12 months, you'd be over the threshold and subject to the regulation, assuming other criteria apply. And then the list goes down. Biometric identifiers, precise geolocation. Notably on precise geo, it's within 1,000 meters, which is different than some other standards in the US as to how precise geo is defined. Personal health data, not limited to covered entities or HIPAA regulated entities. It's pretty broadly defined. Personal financial data would cover things like payment history, so also very broadly defined. It's not just traditional financial information. And then covered personal identifiers. While the threshold is much higher at 100,000, it's very broad and it would include things like IP addresses, device identifiers, MAC addresses. So it's intended to be a very broad set of data that would be swept in by the regulation. So if you're allowing access to this type of data by individuals that are located in a country of concern or would be considered a covered person, which we'll explain what that is, you would be subject to the regulation, and you would have to comply with all the security requirements in order to go forward with that transaction. So in the second set of data that would be covered is US government related data. There's no threshold required for this. So if you're collecting collecting this type of data on one individual, that would be within the scope of the regulation. So it's precise geolocation about designated government facilities. And so there's a long list of government facilities where if you're collecting precise geolocation within that radius, that would be triggering the rule regardless of the volume. And then sensitive personal data that is marketed as relating to government employees. So this one is not as applicable to a lot of companies because of the marketing component. It really gets at more of the kind of like the true data broker industry, but essentially the government is trying to prevent, or protect sensitive information and lists being sold focused on US government employee data. So that's the type of data that's covered. And again, this entire regulation focuses on access to this type of data. It is extremely broadly defined. You can see the definition on the screen, but logical or physical access, it includes the ability to access. So that's pretty conceptually broad. And if you read some of the commentary, it's intentional, it's intended to be broad. So if there is a theoretical possibility of access, that's exactly what the DOJ is trying to prevent against, because they know that these nations that have national security threats are very innovative and able to leverage different data sets in a way to identify information and create profiles. So they're really thinking about that intentionally and have defined access quite broadly. There's also language in there that says that access for purposes of the regulation is determined without considering the applicable security requirements. There's some different interpretations about what that means. I think most likely, based on the guidance that's come out, it means that it's without regard for the security requirements required under this regulation. But it's still a gray area, and the bottom line is that access is determined very, very broadly. So what is a covered person? Again, this regulation is focused on what are called countries of concern. So you see them here: China, Russia, Iran, North Korea, Cuba, Venezuela. China and Venezuela are the ones that have seemed to have been most impactful so far, just in terms of business impact. And there's two different ways that this could be in scope. So providing access to individuals that work for the government of these countries directly, that's less common, or a covered person, which are all of these different categories that could meet the definition of what we call a covered person and would bring you within the scope of the rule. So this would include people that are primarily residents in one of these countries of concern. So if you have employees in China, or you have contractors, partners, vendors in China or Venezuela or one of these countries, you're likely triggering the rule, or they would be considered a covered person. And notably, the Attorney General of the United States has the ability to designate any person, regardless of location, citizenship, as being a covered person that would be subject to the rule. So as we go through this, there's a lot of parallels to kind of the US sanctions framework, and that was the model on which this regulation was designed. There's many differences, but there are some parallels in terms of the diligence and the expectations that the DOJ has in terms of managing compliance. Great. So I mentioned in the beginning, it's broken down into prohibited and restricted transactions. So prohibited transactions cannot go forward at all. They're outright prohibited under the regulation. And what that means is you cannot provide access to the specific transactions identified here, to the data covered by those, to covered persons. So for example, if you had a permanent resident in China and your support team, they couldn't access this information if it's a prohibited transaction. So there's two key prohibited transactions. The first is called data brokerage, and it's a little bit misleading in that it's much broader than how we think of the term data broker in the US traditionally. So it's much broader than the actual data broker laws that regulate data brokers and require registration in the US. This would include similar, the sale, licensing of access to data, or similar commercial transactions, which is extremely broad. So it caution you that when you're looking and thinking about whether or not this applies to you, don't just assume because you're not a traditional data broker that you're not engaging in data brokerage. So that is explicitly prohibited under the rule. And then the second prohibited transaction is the transfer of bulk human genomic data or biological specimens. So that cannot go forward at all under the regulation, even with the security controls in place. And then on the other side, we have restricted transactions. So that includes vendor agreements, so agreements for goods and services, employment agreements, and investment agreements where access to covered data is made available to covered persons. If you're engaging in a restricted transaction, there are significant compliance obligations, record-keeping obligations, auditing requirements, and data security requirements. Regardless of whether or not it's restricted or prohibited, the actual identifiable data itself still cannot be accessed. So even if you're engaged in a restricted transaction, the security requirements still require you to ensure that the covered persons are not accessing the data in an identifiable manner. So the transaction can go forward, but the access to the data itself still is restricted under the regulation. The security requirements are quite onerous. They actually, while they were modeled off the NIST cybersecurity framework and some other industry standard frameworks, they're not a one-to-one mapping, and they do have some additional and new requirements. So For those that are engaged in restricted transactions and adhere to the NIST cybersecurity framework, you may be tempted to say, we don't need to do anything further because we adhere to an industry standard security framework. That may be helpful to get you ahead, but it's not going to necessarily check all of the boxes for what's required under the security requirements. So there's both organizational requirements, system level requirements, and data level requirements. And the organizational and system requirements are mandatory, so you have no flexibility in determining if or how those should be implemented. They're all required, whereas the data level requirements are a bit more flexible in that you have the ability to have some discretion to determine how you would like to implement them. So there's things like access management, patching, log retention. It has a requirement to retain logs for up to 12 months, which is a very long time because of how broadly it's defined and can be expensive. So just flagging that the security requirements are pretty onerous, and they would apply to any system that's a covered system where a covered transaction is taking place. And then on top of the security requirements, there are additional compliance obligations. So the DOJ, after the law took effect in April, late April or mid-April, they also came out and implemented a compliance guide, which kind of shed more light on their expectations as to what is required for implementing the compliance program to adhere with the law. It's very clear from the compliance guide, while this didn't necessarily say it expressly in the regulation itself, that board oversight is required and expected. Senior oversight up to the CEO of organizations are expected to understand the company's compliance obligations and risk appetite and be involved in kind of an oversight for the compliance program. There's also an auditing requirement that would include auditing the security requirements annually, and then a requirement for reports and record keeping. So if you are engaged in restricted transaction, there's quite a bit of heavy lifting from a compliance perspective. And frankly, some companies we're seeing just take the position that it's easier to just not engage in the restricted transaction at all than it is to engage in it and have to implement the security requirements and the compliance and record keeping obligations. So we are seeing that happen as well. So like I mentioned, there are certain exemptions, but they are very narrow. So there's a corporate group transaction exemption, which would exempt transactions between U.S. person, which is a U.S. company most often, or an individual located in the U.S., and its subsidiary or affiliate that's located in a country of concern, for those activities that are ordinarily incident to and part of administrative or ancillary business operations. So I think on first glance, companies see this exemption and think it's quite broad, and a lot of things fall within this category. But if you really start reading the commentary and look in the rules, the examples in the rules, it becomes quite clear that it's narrow. There has to be a clear nexus and justification for transferring the data for those purposes. And just because it's cheaper or more efficient in the DOJ's view is not sufficient reason. There's also financial services exemption, but again, it's limited to transactions or data that is ordinarily incident to and part of the provision of financial services. So there can be things that fall outside of this exemption, even in the context of financial services, because the exemption is quite narrow. And then there's travel, telecommunications, and official business of the U.S. government. But the corporate group and financial services transactions are ones that are, I think, looked at quite frequently. But keeping in mind, even if you are subject to an exemption, it's not at the entity level. So it would be based on the transaction. So a particular transaction could be exempt in one context, but you may have other data processing activities that would not be. So that's important to keep in mind. Other exemptions, things for like personal communications. There are some clinical investigations and drug medical device authorization exemptions. Again, those are also narrow. Like have very specific requirements in order to be able to avail yourself of them. and some of them have additional record keeping obligations if you're going to rely upon them. Go to the next slide. Yeah, so just kind of flagging things to think about. Although this regulation is already on the books, there's still a lot of work to be done. I think companies are still trying to figure out exactly what it means for them. It's again intended to be quite broad. It's important to keep in mind that the law doesn't turn on citizenship. So it's focused on these countries of concerns and ownership and where individuals are located. So you could have a citizen of one of these countries of concern that's physically located in the US, and they would not be considered a covered person under the regulation while they're physically in the US. So there's nuances like that are important to keep in mind, and do a deep dive analysis of where you're actually sending the data, who has access to it, if you have data that's covered under the regulation. And many companies will, because of how broadly it's defined. And then keeping in mind that even if you have foreign business partners under the regulation, even if you aren't giving access to countries of concern, there are also contractual requirements for foreign business partners as it relates to data brokerage. So there's a requirement to prohibit non-US companies and non-covered persons. So for example, a company in France, to have contractual language that would prohibit them from engaging in onward transfers and data brokerage. So there are things to think about, even if you're not doing business in a country of concern directly. So for just quickly, I know we're not going to have time to get into all of this, but before I go to PAPA, just one more thing on the bulk data rule. Even if you determine you are not subject to it, or if you determine an exemption applies, it's important that you are documenting those decisions and that you have a record to show that you thought that through. Because like I said, a lot of companies are taking the position, we're not going to engage in this transaction, or we're exempt for this particular reason, or we're not in scope yet because of XYZ. It's very nuanced, and there's typically a lot of different parties and stakeholders involved to help companies figure out what data they're collecting and who has access to it. So it's important that you have a record of what it was you decided and why you reached that conclusion. And then just quickly on PADFA. So this is a different regime. Like I said, it's administered by the FTC, a bit narrower in some ways, broader in others than the bulk data rule, but narrower in the sense that it doesn't necessarily apply across the board to most US companies like the bulk data regime does. This is a little bit more narrow, and it applies to more traditional types of data brokers, although the language is still broad. And so that's a different regime. The countries are more narrow, so you won't see Venezuela on here. Cuba's not on there. I just flag it to show that there's an additional data transfer regime that's been introduced in the US, and there's probably more to come. So just to highlight kind of the trend that Loki highlighted, and that you see here with both of these regimes in the US. One's a criminal enforcement, this is civil enforcement. But it's just indicative, I think, of the way the US is starting to think about data, primarily from a national security perspective, but also from a privacy perspective as well.
Yeah, so we're wrapping up. Thank you, Kaylee. Well, the bottom line is, before you start a project that involves data, it is impossible not to think about, the applicability of transfer rules. And that means you need to know your data, where they are from, know your vendors. And often, I have to say, workarounds are possible, but they need then to be implemented at the start. It is very difficult to do that once the project has been implemented and then try to stick some plasters and solve it. So what we see, and we only took, the US and the EU, but we will see many other countries for similar reasons, having data transfer regimes that is either for national security or sold under the banner of privacy, but actually serving national security interests. And we will see just more and more of it. And the complexity will just increase. So Yeah, we thought it would be helpful just to show these regimes so you are aware of them, and there's a red flag when you start a project to first inventorize whether there are any issues. Kaylee, do you have anything to add? Because otherwise
Uh,
we're closing up.
Yeah, thank you. I think, of course, none of these regimes are compatible and identical to one another. They have different
They're
requirements.
not.
That would be too easy. But I think really a core principle of all of these is that there's an expectation that you know what data you have and where it's going, and there's kind of like the head in the sand approach is not acceptable. Like even if it requires difficult conversations and effort and money to figure out what data you have and where you're providing access to it, that's the point. And so I think that's the point of all these regimes. And so I think there's only going to be more, not less, of this type of regulation going forward.
Thank you. Well, it was a pleasure to be with you, and hopefully till another time. Bye bye.
Thank you.
Thank you both so much for this wonderful presentation. We're really lucky to be able to benefit from your expertise. To our audience, we really hope that you enjoyed the program. Stay tuned for more Privacy Law Forum Life Sciences programs coming soon.